un po' di velocità, devo chiedere agli amici che tengono invece un'esposizione un po' più articolata di essere brevi. Partiamo dallo studio Samela e Williams, Furio Samela e lei, che ci parlerà della pirateria e della perdita totale in occasione dell'Orangrino. Prego.
In the meantime, I would like, after this session, we will have a very short coffee break. It should have been an aperitif. And we will not have lunch, because we don't have time. No, we will have a lunch upstairs, gently offered by Varsila, while the first coffee break is offered by Cantieri Palumbo. I thank Antonio Palumbo and Varsila for the lunch. There is, after lunch, a very interesting piracy session, Managing the Risk, which is the longest session. So we will try to make it shorter. I'm a speaker, and we'll try to regain part of the time lost. I apologize for this delay. I hope that Furio is ready.
Yeah. Good morning, ladies and gentlemen. Thanks for being here. And as explained by Paolo D'Amico earlier this morning, piracy has now become a very important issue in the shipping market. So I would like to give you some highlights on how piracy is addressed in shipping loan agreements. We can start with the definition of piracy. Piracy can be defined as the act of boarding any ship which is lying to a port or navigating into the open sea with an intent to commit theft or any further crime, and with an intent or capacity to use force in furtherance of that act. Under an insurance law standpoint, piracy risk is considered an ordinary risk, which shall be for the account of the insurers. Indeed, according to our Italian Navigation Code, damages and losses to insured assets shall be for the account of insurers. Obviously, piracy is also provided for in the ITC clause, in the ITC and in the ICC. This slide shows where the pirate attacks occurred in the last 2 years, and you can see that most of them happen in the coasts of Somalia. And on the right side of the slide, there are some numbers, some statistics. You can see that pirate attacks rose sharply in the first half of this year compared to the first 6 months of 2010, and most of the pirate attacks are attributed to Somali pirates. As explained and described by Paolo D'Amico earlier this morning, the Italian government has approved a law decree which was in July, which was converted into law in August 2011, which authorizes the Ministry for Defense to enter into agreements with the Italian Shipowners Association for the deployment of military forces on board Italian flagged vessels, which are the nuclei militari di protezione. Upon certain requirements being met, there is also the possibility to deploy private armed guards on board Italian flagged ships, and all the costs relating to deployment of whether military forces or private guards shall be borne by the ship owners concerned. On the same date when the Bulker Monte Cristo was released from pirates through US and British forces, Defense Minister Ignazio La Russa signed a deal, a very important deal with Confitarma, which allows the use of personnel on board Italian flagged vessel transiting pirate-infested waters in the Indian Ocean. So, as said by Paolo, there is a very strong intent of the Italian government to try to fight piracy. But how is piracy usually addressed in shipping loan agreements? A standard definition of total loss, which you can find and you have seen in shipping loan agreements, is the following. Total loss is, in relation to a ship, is any actual, constructive, compromised, agreed or arranged total loss of the ship, or any expropriation, confiscation, requisition or acquisition of the ships, whether for full consideration, a consideration which is less than its proper value, a nominal consideration, or without any consideration, which is effected by any government or official authority or by any person claiming to be or to represent a government or official authority, excluding a requisition for hire for a fixed period not exceeding 1 year, unless the ship is within 1 month redelivered to the borrower's full control. Total loss is also any arrest, capture, seizure or detention of the ship, including, that is important, including any hijacking or theft, unless also in this case the ship is redelivered within 1 month to the borrower's full control. So it is clear that piracy falls within this category, within the definition of total loss. It is difficult now to, and I will explain later, to consider whether piracy is an actual or a constructive total loss. In any case, upon a total loss event occurring, the borrower is obliged to prepay the loan, because the occurrence of a total loss event is a mandatory prepayment under shipping loan agreement. And the borrower shall be obliged to prepay the loan on the total loss date, which is a definition which is very linked to the total loss definition. Total loss date in relation to the ships means, depending on the kind of total loss, in the case of an actual total loss, the date on which the total loss occurred, or if it is unknown, the date when the ships was last heard of. In the case of a constructive, compromised, agreed or arranged total loss, the total loss date is the earliest of the date on which a notice of abandonment is given to the insurers, and the date of any compromise, arrangement or agreement made by on behalf of the borrower with insurers of the ship, in which the insurers obviously agree to treat the ship, to consider the ship as a total loss. In the case of any other type of total loss, on the date or the most likely date on which it appears to the lenders and basically the agent or the security trustee that the event constituting the total loss occurred. As said, if the ship becomes a total loss, the borrower shall be obliged to prepay the loan, and usually in standard loan agreements, the mandatory prepayment clause obliges the borrower to prepay the loan on the earlier of the date falling 180 days after the total loss date and the date of the receipt of the insurance proceed by the security trustee. I say the security trustee because one of the securities as you know, in the shipping market is the assignment of insurances in favor of the security trustee or the agent, as the case may be. So if the ship becomes a total loss, the borrower shall be obliged to prepay the loan whether 180 days after the total loss date or the date when the insurance proceeds are received by the security trustee. But what happens in practice? If a total loss is an actual total loss, for example, the ship, in the case of a ship sinking, it is normal practice that insurers will pay to the security trustee the insurance proceeds relating to the actual total loss, and the security trustee will allocate this insurance proceeds to the prepayment of the loan, so to repay the loan. The problem arises in the case of pirate attacks, because what the borrower shall prove to the insurers is that either an actual total loss has occurred in the event of a pirate attacks or a constructive total loss has occurred as a consequence of a pirate attack. But it is very difficult for the borrower, first of all, to prove that as a result of a pirate attack, an actual total loss occurred, because the notion of an actual total loss has an impact on the property of the vessel, on the proprietary interest in a vessel. And a normal pirate attack, without more, has no impact on the proprietary interest in a vessel. So it will be difficult for the borrower to prove that it was irretrievably deprived of the ship, because you have to prove that it is not possible under a legal and under a physical point of view to recover possession of the ship. So the borrower, it is difficult for them to prove that as a consequence of a pirate attack an actual total loss has occurred. Obviously, the borrower can claim that a constructive total loss has occurred. But also in this case, as the constructive total loss has an impact on possession of the ship, the borrower must prove that the recovery of possession is unlikely. But if it is possible and if the borrower pays the ransom, that means that there is the possibility for the borrower to regain possession of the ship. So in most of the cases, if the borrowers, as a result of a pirate attack, claim that a constructive total loss has occurred and as a consequence send a notice of abandonment to the insurers, because it is possible to regain possession of the ship through the payment of the ransom, the insurers will decline the notice of abandonment, and so will not consider that a constructive total loss has occurred. I will not go into detail regarding the legitimacy of the payment of the ransom under Italian law, and in particular in relation to law number 82 of 15 March 1991, in respect of which my colleague Vittorio Porzo has written a very clear and very important article. What I would like to say is that insurers would normally decline the notice of abandonment in the event of a pirate attack and in the event of the borrower claiming that a constructive total loss has occurred. It may also happen that the borrower does not intend to send a notice of abandonment because it is confident that possession of the ship may be regained. If a notice of abandonment is declined by the insurers or is not sent to the insurers by the borrower, a total loss will not occur under an insurance standpoint. However, a total loss will occur under the ship loan agreements, the shipping loan agreements, because as we have seen before, if the ship is not redelivered within 1 month to the borrower full control, a total loss event has occurred under the shipping loan agreement. and as a result, the borrower would be obliged to prepay the loan even without having received the insurance proceeds, because the total loss is not considered an insurance event under insurance policies, is obliged to prepay the loan on the date following 180 days after the total loss date, which would be, in the case the notice of abandonment is sent, the date of the sending of the notice of abandonment. Otherwise, the date or the most likely date on which it appears that the lenders appears to the lenders that the event constituting the total loss has occurred. What I would like to highlight with this very brief presentation is that there could be a discrepancy between how a total loss and consequently a pirate attack may be treated under shipping loan agreements and under insurance policies. Obviously, for ship owners, in negotiating the clauses of the loan agreement, it would be very important to try to extend the term beyond which a total loss event occurred. For example, this is a standard clause, but obviously ship owners can negotiate that any a total loss event occurs if an arrest, capture, or seizure it happens, but the ship is redelivered, for example, within 2 months or 3 months to the borrower's full control. On the other side, banks in negotiating shipping loan agreements need to make sure that there is a mandatory prepayment event, even if the insurers do not pay insurance proceeds to the borrower, which means that in negotiating the total loss date, banks shall make sure that there is a mandatory prepayment event, even if the total loss date has not occurred under insurance policy, and consequently the security trustee has not received the insurance proceeds as a result of the pirate attacks. Thank you.